Hi friends, I'm AKS Krishnan. I'm Chartered Accountant. I'm taking CA Final Law classes in Chennai. Now in this video, we are going to see how to do self-study for CA Final Law. See, the portions of CA Final is split like Companies Act as well as Allied Law. In Companies Act, we will be having both 1956 as well as 2013 Act. In 1956, we have portions like from section 123 to 127, that is dividend, then followed by 128 to 138, that is our books of accounts and books of accounts, uh, then followed by 149, 139 to 148. This is audit and auditors. Then 149 to 172 directors. Then 173 to 195 meetings. Then 196 to 205, this is managerial remuneration. See, dividends 5 marks assured. Then books of accounts 5 marks assured. Then audit and auditors 5 marks assured. These three we'll be studying even from our IPCC syllabus. From IPC, so 15 marks from our IPC syllabus. And actually, these three topics even covered in auditing standards, or means auditing subject also. And our core portion is actually directors. The directors will be like, see, directors I can split into three: the basic directors, disqualification, appointment, etc. This is section 149, types of directors, then appointment, disqualification, till 172. This they will ask for 10 to 12 marks. Then out of these questions, I can tell like independent directors, rotational directors, disqualification of directors. These three are very important topic. And followed by 173 to 195, that is meetings and powers of board. In that, 173 is important. Then 185, that is loans to directors. 188, that is related party transactions. Um, and last few sections like insider trading, non-cash transaction, derivative transaction, those things they may be touched. So basically, board meeting, that meeting is there. Then 179, that is power of board, that section. So 173, 179, 185, 188. Out of these four topics, these four sections, you can expect one question. And followed by managerial remuneration, section 197 is a very good section, like overall managerial remuneration. And 203, that is key managerial personnel, who can be key managerial personnel. This topic should be covered. Then see, in inspection chapter, that is from section 206 to 229, only few sections are very important, like 206, then 210, then followed by related parties investigation 219, then protection of employees 218, then inspectors report, I think should be 223. So those four chat means four questions you can study. And 212 SFIO, that is serious fraud investigation officer. So that portion is also because it's only offense which is cognizable offense, non-bailable. So that you can study. Then um, foreign company section 380 is there, which is for documents to be filed for foreign company, and prospectus and IDR, that is Indian depositors. Then this time even whether consent is necessary or not, that question can also be asked. So because for foreign company which is requiring to file prospectus, they are compulsory, they have to file a consent with the expert. So they have to get the consent. That questions may be coming. This time we are expecting that. Then companies capable of being registered, as of now we haven't touched it. But see, in that chapter we can expect one question which is like carry forward of liability, taking over the penal cases of the existing society or the partnership firm. That questions can be tested. And for offenses and penalties, see like 447 is already tested. So 448, like say false statements or false evidence may be tested. Ultimately, like it's end up like 447 penalty. And see, misappropriation of the asset or withholding the asset, that questions can be asked, that maybe it's 452. So those two things. Then for other penalties like uh, 127, dividend penalty can be asked. Then 147, auditor's penalty can be asked. Then 157 is DIN penalty, and 159 DIN penalty. Out of these two questions, any one questions can be asked. Then 447, which we have discussed. So this 127 dividend penalty, 147 auditors penalty, 447 fraud, and 157 followed by 159 DIN penalty. This are like penalties, like important penalties. So this can be touched. And see, allied laws, SEBI, we have few topics in SEBI. Like we can split the SEBI into two types, one is preliminary SEBI and another one is ICDR. In preliminary SEBI, you should know what is the power of SEBI, what is court, special courts, etc. And insider trading, obviously. Uh, then what is the penalty for brokers, intermediary, which is, and why SEBI to promote a securities market, etc. Those questions. Then ICDR, we have concepts like bonus issue, preferential issue, differential pricing, then book building process, green shoe options, and basic IPOs guidelines, conditions for IPO. We have 6 conditions like tangible assets, then previous year profits, average issue, before name, after name change, those things. So that questions we can expect, because even though it's repeatedly asked, but it's worth asking those sections. Then qualified institutional placement program, that concept is there. Uh, so this concept, like out of some 8 concepts, at least 2 concepts they may be testing, and adjudicating authority also is there. Then followed by FEMA. FEMA, we have like current account transaction, capital account transaction, and foreign import export rules. Then actually in FEMA now it's actually very liberal questions, like they will be giving certain limit or amounts, whether you need RBI permission or central government permission they are asking. So those questions, and adjudicating, how to adjudicate, what is the compounding authority, who is the compounding authority, those things. So adjudication, civil powers of the authorities. Then followed by SCRA. Mostly in SCRA, straight questions will be asked. They want any twisting question, they will be asking straight questions. This time, maybe derivatives, what is derivatives, or that kind of questions, straight questions can be asked in SCRA. Then in interpretation, I think this time exceptional construction we can expect, and or shall, must, may, discretionary, mandatory, those rules. And in primary, secondary interpretation rules, we can expect nocivo lasocus or expressive unis exclusio algarius. Out of these two, they can ask anyone. And in aids of interpretation, like preamble, proviso, out of that they can ask any one thing. Then Competition Act, so Constitution of Selection Committee, Tribunal, or major means the main constitution they can ask. And sometimes combination they can ask. What is combination? Definition of combination they can ask. Then insurance, surely this time that capital thing will be there, because the new introduction of capital for health sector, then net owned funds 5,000 crores to be brought in. Also like FDA insurance 49 percentage, and GIC, that is General Insurance Company, and other even government-owned insurance companies eased now. Even they can go for private borrowings, means private shareholdings. They can liquidate their shares like that. So these things they can be tested. And surface, state questions like what is securitization or what is reconstruction or what is like process of doing that, uh, or what is enforcement of security interest, what is the minimum time of notice if they are not responding, then what time again notice. Those questions they can test. Mm. Then PMLA, I think the penalty may be asked like 3 years to 7 years. The penalty for Part A and Schedule A and Schedule C. That two things can be asked. What is the penalty and what is the duty of the banks to report? Means bank has to give that over and above the transaction like 10 lakhs. They have to report it to RBI director. Those things can be asked. And from Companies Act 1956 angle, compromise and arrangement section 391 to 396. See what is the scheme, how does 391 starting, what is the special majority like 51% in numbers and 71% in voting, so that value should be voting. Those things can be tested. That is the scheme and how the court will organize that meeting. And undertaking transfer 394 and 395, if the person is having like already the existing shareholders having less than 10 percentage, more than 10 percentage, what is the procedures? So whether what we have to consider, what we should not consider, maybe that questions can be asked. According to me, this time section 395 is the highlight, I guess. So 395, that too with special majority, without considering the voting, without considering the new acquirer, that is transferee company, that 51 percentage uh, and 75 percentage they should vote no. That scenario of 395 they can ask that. Then producer company, I guess members removal. When what is the situation of members removal? Then minimum maximum number of directors, CS appointment, then objects of producer company, then loans to directors and members. I guess these questions and conversion of interstate cooperative society to producer company. These questions you have to study. Then oppression mismanagement, case law is there, like case study they will give, majority oppress minority, minority when minority can oppress majority. That Simpria Infoundry case, this and the Sebastian City Hospital case. I think those two cases they can test this time. And what is the relief for the oppression? What is the CLB's relief under oppression? That questions can be asked. So I think this is the fair idea of how to crack this law this time, November 2015. I guess I will go for another video for discussing the important questions. So catch up